Close that folder!
Look at you, standing in my courtroom like you belong here. He did not say it as a question. He said it the way a man says something he has been saying his whole life. Slowly, with satisfaction, into a silence that he himself created. Judge Chester Aldine leaned back in his chair and let that silence stretch. He had 22 years of practice at this, 22 years of knowing that a pause from the bench feels, to the person standing below it, like falling. The woman at the podium did not flinch. She held a manila folder against her chest with both hands, fingers flat, and she looked at him without expression. Not defiance, not fear, something quieter than both. Her hair was natural, worn loose to her shoulders. Her blouse was dark cotton. Her slacks were pressed. She looked like a woman who had been somewhere important before she came here, and who would be somewhere important again after she left. Aldine did not see any of that. What he saw was what he always saw when a black woman stood at that podium, an inconvenience to be processed and dismissed. If this kind of story matters to you, hit subscribe and stay with us. What happens next will not let you look away. Is that what passes for professional attire where you come from? He gestured vaguely at her general direction, a slow, circular wave of the hand that managed to encompass her hair, her clothing, and apparently her entire existence. You're in a court of law, ma'am, not a community event. The courtroom was not large. Caldwell County Circuit Court, Room 4, seated perhaps 60 people in its gallery on a full day. Today it held maybe 20, a handful of other petitioners waiting for their dockets to be called, 2 attorneys seated at side tables with their laptops open, a bailiff standing near the east wall, and at the clerk's desk in the corner, a small woman named Dahlia Oren, who had been recording proceedings in this room for 11 years. Dahlia did not look up from her keyboard, but her typing slowed. The woman at the podium, whose name was Simone Bryce, said nothing for 3 full seconds. Not because she had no response, because she was counting. There was a laminated notice posted on the east wall of Courtroom 4, directly above Dahlia's desk. It had been there so long, the edges had gone brown. Most people in this room had stopped seeing it years ago. Simone had read it 40 minutes earlier while she waited in the hallway. The notice cited the Georgia Code of Judicial Conduct, Rule 2.3, under the heading Bias, Prejudice, and Harassment. A judge shall not, in the performance of judicial duties, engage in conduct that manifests bias or prejudice based on race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status. She had read it. She had noted the case number on the wall mount frame. She had written the frame number in her small notebook, 3rd line from the top of page 14. Now she set the manila folder on the surface of the podium, pressed her fingertips against it once, lightly as if confirming something, and looked at the judge without blinking. "I'm here on behalf of my aunt, Naomi Bryce," she said. "Case number CV 2024-1183. The citation concerns an alleged code violation at the property located at 442 Harlan Street. We have documentation showing the violation was corrected and the renewal certificate was filed on time." Aldine stared at her. Then he looked at the folder as though it had personally offended him. "I didn't ask you what you're here for. I asked about your presentation." He let the last word land like a door closing. In the gallery, an older woman in a floral dress gripped the wooden rail of the bench in front of her with both hands. That was Naomi Bryce. 71 years old, 5'2", church clothes pressed because she believed in showing up correctly to places that held power over her. She had been showing up correctly to places like this her entire life. She had told Simone that morning, on the phone, that she was scared, not of losing the case, of being spoken to the way she knew she was going to be spoken to. Simone had told her, "Come anyway, I'll be right there." Naomi was right there. So was Simone. and so was Chester Aldine, who had not yet understood what was in that folder or whose name was on it. The folder sat on the podium between them, closed, blue along the spine where the commission's color coding ran. Neither of them moved toward it. Outside in the hall, past the heavy oak doors that Simone had walked through 45 minutes ago, the morning was already warm. Caldwell County sat in the central Georgia plateau, flat land, red clay roads at the edges of town, a downtown that ran for 4 blocks before it gave way to gas stations and vacant lots. The courthouse was the tallest building in the center of it, 4 stories of pale brick built in 1941, and it had a kind of authority that came not from beauty, but from age, from the accumulated weight of every decision ever made inside it. Some of those decisions had been just, some had not. Simone knew which category Judge Chester Aldine's decisions tended to fall into. She had been building a file on that question for 14 months. The folder did not move. Aldine had not noticed its color yet. He was still looking at her hair. 3 days before she walked into Courtroom 4, Simone Bryce sat in a conference room on the 7th floor of the State Judicial Conduct Commission's building in Atlanta and listened to a man named Ezra Cole explain exactly how careful she needed to be. Ezra was the commission's supervising attorney, 50 years old, wire-rimmed glasses, the kind of quietly methodical mind that assembled complex legal arguments the way other people assembled furniture, piece by piece, with a manual he had written himself. He had been at the commission for 19 years. He had seen judges retired, censured, reprimanded. He had seen one removed. He had never seen a case quite like Chester Aldine's. 5 complaints in 36 months, Ezra said. He did not look up from the summary in front of him. 5 separate individuals, none of whom knew each other, none of whom were represented by the same attorney, each describing substantially the same behavior. Contemptuous language from the bench. Racially inflected commentary on defendant's appearance, speech, and background. Sentencing disparities that our data analysts flagged as statistically significant. He turned a page. And not one of those 5 complaints went anywhere. 3 were administratively dismissed. 2 are still technically pending review, which in the commission's language means they have been placed in a filing cabinet that someone will open, approximately never. Simone looked at the folder on the table in front of her, her copy of the case file. She had read it twice already. She knew why the complaints had gone nowhere, because going somewhere required a victim to stand in front of the commission and testify, and standing in front of the commission meant potentially being called back into Chester Aldine's courtroom for whatever matter had brought them there in the first place. The system had designed its own silence. It was not accidental. "What's my cover?" she asked. "Your aunt has a pending citation," Ezra said. "Code violation on a rental property she's owned for 14 years. The citation was issued in March. She's been trying to contest it since April. She was assigned to Aldine's docket." He slid a second sheet across the table. "It's a real case. The violation was real, a minor one, fence height at the property line. She corrected it in April and filed the renewal certificate. By all rights, a substitute judge would dismiss this in under 3 minutes. But Aldine has rescheduled it 4 times. He hasn't dismissed it." "He's running out the clock," Simone said. "He may be, or he may simply enjoy having it on the docket. Some judges," Ezra paused, selecting his next words with care, the way he selected everything. "Some judges develop an attachment to the capacity to inconvenience people. It becomes its own reward." Simone thought about her aunt. Naomi had called her the previous week, not asking for help exactly. She would never ask for help exactly, but describing the situation in the careful, exhausted language of someone who has been circling a problem for so long they have stopped being surprised by it. 4 reschedules. 4 times she had arranged a day off from the part-time job she still worked at 71. 4 times she had pressed her church clothes and taken the 40-minute bus ride to the courthouse and sat in a gallery for 2 hours before being told to come back. She doesn't know about the commission case? Simone asked. She knows you're coming with her. She believes you are there as a supportive family member with some legal background. She does not know your current role. Ezra looked at her directly for the first time. That needs to stay exactly as it is. Understood. You will observe, you will document, you will not identify yourself. If Aldine says something that constitutes a violation on the record, you note it, you note the exact language, you note the time. If he issues an order that is procedurally improper, you note it. You do not intervene beyond the normal scope of what a lay representative would do in a small claims proceeding. He folded his hands on the table. You are not there to confront him, Miss Bryce. You are there to watch him be himself. That has always been enough with Chester Aldine. We just have never had anyone in the room qualified to record it properly. Simone nodded once. She picked up her folder and stood. At the door, she paused. The 5 people who filed those complaints, she said, what happened to them after? Ezra was quiet for a moment. One lost a civil matter that her attorney believed she should have won. One was assessed a fine that was overturned on appeal 18 months later. One received a custodial sentence for a misdemeanor that a different judge, same jurisdiction, same charge, same week, had resolved with community service. He removed his glasses and set them on the table with a soft click. The other 2 withdrew their complaints before they were formally processed. I don't know why. I can speculate. Simone did not need him to speculate. She already knew. She left the building through the lobby and walked to the parking structure on Mitchell Street. The morning was bright and already beginning to heat. She sat in her car for 8 minutes before starting the engine. Not because she was uncertain, but because she had learned, years ago, to sit with difficult things before driving through them. Then she started the car and drove south. She arrived in Caldwell County the following evening and checked into a motel 2 miles from the courthouse. The room was clean enough. She unpacked her single bag with the efficiency of someone who has done this many times. Laptop on the table, charging cables positioned near the outlet, small notebook in the top drawer where it would be within reach in the dark. The recorder, which was the size of a thumb drive and clipped to the inside breast pocket of her jacket, she set on the bedside table and confirmed that it was charged. She reviewed the file again that night. She reviewed it again at 5:45 the following morning over bad coffee from the motel's lobby. She did not review it on the morning of the hearing itself. By that point, she knew it well enough. What she did on the morning of the hearing was call Naomi. Baby, Naomi said, answering on the second ring. Her voice had the particular quality of someone who had been awake for an hour already, but had not yet spoken to anyone. Slightly soft at the edges, warming up. I pressed my green dress, the one with the collar. That's perfect, Simone said. I'm scared. I know, come anyway. A pause. In the background, Simone could hear the particular sound of Naomi's kitchen, a faucet, the creak of a cabinet, the small rituals of a woman who has survived harder mornings than this one. You'll be right there? Naomi asked. Right there. Then I'll come. They met at the courthouse steps at 8:15 a.m. Naomi was in the green dress with the collar, her silver hair pinned back, her citation paperwork in a plastic folder she had bought at the dollar store and reinforced with clear tape at the spine. She had brought everything, the original citation, the correction photographs with timestamps, the renewal certificate with the county seal, the mailing receipt. She had organized it in the order Simone had told her, tabbed with sticky notes in 4 colors. Simone wore dark slacks, a cotton blouse the color of slate, and flat shoes, reading glasses on a lanyard around her neck. She looked like someone's organized relative. She carried a tote bag that held her laptop, a legal pad, 2 pens, and a blue folder she did not open on the steps. They went through security together. The officer at the scanner waved Naomi through after a brief check. He asked Simone to open her bag. Of course, Simone said, and held it open without comment. Inside the main corridor, they found the docket board. Room 4, 9 a.m. Case number CV20241183, Bryce, N., was listed fourth on the morning's docket. Fourth, Naomi said, reading the board. So we wait. We wait, Simone agreed. They found seats on the wooden bench outside room 4 and settled in. Naomi clasped her plastic folder on her lap. Simone opened her small notebook, the same one she always carried, college-ruled, black cover, bought in bulk because she went through them quickly, and began writing. The time, 8:22 a.m. Location, Caldwell County Circuit Court, main corridor, room 4, anteroom. Docket position, 4. She wrote the name of the security officer. She wrote the model number of the scanner, which was printed on a sticker affixed to its side. She wrote the name of the clerk she could see through the small window in the courtroom door, Dahlia Oren, which was printed on the desk nameplate visible from this angle. Naomi watched her write. "What are you doing?" "Just keeping track," Simone said. Naomi looked at the notebook, at the small, careful handwriting, at the way Simone's eyes moved to a detail, the nameplate, the door number, the time on the wall clock, and then back to the page without expression. "You always been like this," Naomi said finally. Not a question, a recognition. "Since I was about 12, Simone said. Naomi almost smiled. "Your grandmother said the same thing. Said you used to write down what everybody said at dinner. I wanted to remember accurately. And now?" Simone clicked her pen closed. "Same reason." They sat for another 20 minutes. 3 other parties moved through the hallway. A young man in a collared shirt who paced until his attorney arrived. An older couple who spoke quietly in Spanish near the water fountain. A woman alone who stared at her phone without moving her thumb. The small ecosystem of people who needed something from a court that had not yet decided whether to give it. At 8:44 a.m., a woman came down the corridor and stopped at the courtroom door. She was perhaps 60, with steel gray hair pulled tight, reading glasses on a beaded chain, and the particular bearing of someone who has spent decades as the first and last checkpoint between the public and a judge's patience. She wore a county ID badge on a lanyard and carried a clipboard with the morning docket on top. Flora Weston, court administrator. She had been managing room 4 for 16 years. She looked at the people on the bench, ran her finger down the clipboard, stopped at Naomi's name. "Bryce?" Naomi raised her hand slightly. "Yes, ma'am. You filed a supplemental correction certificate." "I did, back in April. It's in my..." "Which form did you use?" Naomi opened her folder carefully and pulled out the renewal certificate. "This one, the one they gave me at the front counter." Flora looked at it. She turned it over. She looked at the back, which was blank, and then at the front again, as if something had changed in the interim. "This is the old form," she said. Naomi looked at Simone. "The renewal procedure updated in February," Flora said. "New form required from February 1st forward. Anything filed after February 1st on the old form has to be refiled on the current form." She held the certificate back toward Naomi with 2 fingers, the way a person returns something they found mildly distasteful. "The correction was made in April," Simone said, keeping her voice level. "The renewal was filed in April. That form was available at the county clerk's counter in April. It was issued to my aunt by the clerk at that counter." "I'm not disputing when it was filed," Flora said, without looking at Simone. "I'm telling you what form is required." "Then I'd like to know where the current form is available," Simone said, "because the county's online portal shows only one active renewal form, and the version number on that form matches the one my aunt was issued." Flora's clipboard shifted slightly, a small adjustment but visible. "The online portal may not have been updated." "Then the discrepancy is on the county's end," Simone said, "not my aunt's." A pause. Flora looked at Simone for the first time directly. Not with hostility exactly, but with the particular appraisal of a person who has just realized the person they were dealing with is not the person they assumed they were dealing with. She looked at Naomi. She looked at Simone again. "Take your seat inside," she said. "The judge will address it." Simone and Naomi exchanged a look. Simone wrote 3 words in her notebook: form discrepancy, exhibit, and followed Naomi through the door. Brock Callum was the bailiff for Room 4. He was broad-shouldered and deliberate in his movements, the kind of man who did not hurry because he had never needed to. He stood near the east wall, to the left of Dahlia Oren's desk, and when the door opened, he looked at the new arrivals the way a man looks at a parking lot, scanning for what doesn't belong. He watched Naomi find a seat in the gallery. He watched Simone take the seat beside her. Then he walked to where Simone was sitting and stopped. "Bag check," he said quietly. Simone looked around the room. The young man with the attorney had come in before them. The attorney had a briefcase. Neither had been asked for a bag check. "Of course," Simone said again, and held the tote open. He looked inside. He moved a hand through it, not carelessly, but with a searching quality that was slightly more thorough than procedure strictly required. He looked at the tote bag itself, at the laptop, at the legal pad. He did not look at the blue folder. He stepped back without comment and returned to his position near the wall. Simone straightened the tote on her lap. She did not write anything in her notebook yet, but she noted the time on the wall clock and the clock's position directly above the case file shelf and the name on the shelf's label. Room 4, Aldine, CJ. 3 cases were called before Naomi's. A small property dispute resolved in 11 minutes. A permit issue withdrawn by the petitioner. A contract matter continued to a later date over the objection of the plaintiff's attorney, who said something quietly heated to his colleague as they gathered their papers. Jasper Noel arrived for the 3rd case and stayed. He was the city attorney assigned to Aldine's civil docket. Mid-40s, tall, with a studied informality that suggested he had spent considerable effort making himself appear at ease in rooms where he held advantage. He set his laptop at the plaintiff's table, glanced at the gallery, and when his eyes reached Simone, they paused for just a fraction of a second longer than they paused anywhere else. He leaned toward Flora, who had taken a seat near the clerk station. He said something Simone could not hear. Flora responded with a small tilt of her head toward Naomi. Jasper looked at Naomi, then back at Simone, then at his laptop screen. "Is she the property owner?" he said to Flora, not quietly enough. He glanced once more at Simone. "Or just the friend?" He drew the last word out by about half a syllable. Not long enough to be a provocation he would have to defend. Long enough to land exactly where he intended. Dahlia Oren's typing did not slow this time, but her shoulders rose slightly, then settled. Simone wrote in her notebook, "Noel J., just the friend, 8:51 a.m. 2 minutes later, the door at the back of the room opened, and Chester Aldine walked in. He was 63 years old and carried himself with the comfortable authority of a man who had not been meaningfully challenged in a very long time. Silver-haired, well-fitted in his robe, the robe itself pressed and clean in a way that suggested he had help with such things. He moved to the bench without acknowledgement of the room and sat with the practiced ease of 22 years in the same chair. He adjusted a pen on the surface in front of him. He opened the docket folder. He did not look up. "Next matter," he said. Dahlia called it. "Case CV 2024-1183. Bryce, N. versus Caldwell County Code Enforcement. Property citation, 442 Harlan Street." Naomi rose from her seat and walked to the petitioner's podium. Her movements were careful and deliberate. The posture of a woman who understands that everything she does right now is being observed and evaluated. She set her color-tabbed folder on the surface and smoothed the front of her dress once with her palm. Aldine looked at her over the top of his glasses. Then his gaze shifted left, to where Simone was walking toward the podium as well. He let Simone reach the podium. He watched her place her legal pad on the surface beside Naomi's folder. He watched her uncap her pen. He looked at her hair, at her blouse, at her flat shoes, at the tote bag on her shoulder. Then he said it. "Look at you, Standing in my courtroom like you belong here. The room went still in the particular way that rooms go still when something has been said that cannot be unsaid. The young man near the gallery wall straightened slightly. Jasper Knoll did not look up from his laptop, but his hands stopped moving. Dahlia Oren's typing ceased entirely. Naomi's fingers tightened around the edge of her folder. Simone did not move. She stood with her weight distributed evenly, pen uncapped, legal pad on the surface, and she looked at Chester Aldine with the focused attention of someone who is listening very carefully to every word. "I'm here on behalf of my aunt, Naomi Bryce," she said when the pause had run its course. "Case number CV20241183. The citation concerns an alleged code violation at the property located at 442 Harlan Street. We have documentation showing the violation was corrected and the renewal certificate was filed on time." Aldine set down his pen. He leaned back in his chair. "I didn't ask you what you're here for," he said. "I asked about your presentation." "Your Honor," Simone said, "I'm the lay representative for the petitioner. Under Georgia procedural rules for non-attorney representation in civil small claims matters." "I know what procedural rules say in my own courtroom," Aldine said. There was no heat in his voice. That was, in certain ways, worse than heat. He spoke with the unhurried confidence of a man who has made people feel small so many times it has become effortless. "What I'm asking is whether you thought this through before you walked in here. Because walking into a courtroom with that," another vague gesture encompassing her person, "does not project the kind of seriousness this proceeding requires." In the gallery, Naomi made a small sound that she immediately suppressed. Simone wrote one word on her legal pad. She wrote it in the same quiet motion she had been using for everything else. No hesitation, no drama, just the cap off and the pen moving and the cap back on. The word was time. She noted 8:58 a.m. beside it. "I'd like that comment noted in the record," she said, "for procedural purposes." Aldine looked at her. A brief flicker crossed his expression. Not quite surprise, but something adjacent to it. The request was precise. It was the kind of request someone makes when they understand what a record is and what it is for. He had not expected that. "Noted," he said, with the tone of a man granting an indulgence he did not think warranted. "Now, let's hear the petitioner's statement. And I'll warn you, I've seen this type of correction certificate filing before, and they are frequently incomplete." He looked at Naomi as he said this. Naomi began to speak. Naomi had practiced. Simone knew this because they had gone over it the previous evening at the motel, sitting at the small round table near the window with the correction photographs spread between them. Naomi reading her statement aloud 3 times until the words stopped sounding rehearsed and started sounding true. Standing at the podium now, Naomi found her practiced voice. She explained the timeline in sequence. The original citation issued March 7th, the fence adjustment completed March 28th, the photographs taken March 29th with the county's correction portal open on her phone to confirm the required height, the renewal certificate requested at the clerk's counter on April 3rd and submitted that same day. She held up the tabbed folder and opened it to the first section. "I have the original citation, the contractor's work order, the correction photographs with timestamps, and the county-stamped renewal certificate. All of it is in order." Aldine had not looked at the folder. He was looking at a point somewhere above and to the left of Naomi's head, with the expression of a man waiting for something to be over. "Ma'am," he said, when Naomi finished, "the form you submitted, has it been confirmed as the current version?" "Yes, Your Honor. My niece, my representative, just confirmed with the administrator outside that—" "I'm not asking your niece, I'm asking you." Naomi blinked. "The form was given to me at the clerk's counter, Your Honor. I used the form they gave me." "That's not a confirmation of the current version. That's an explanation of where you got it." He finally picked up his pen again and tapped it once against the bench surface. "Ms. Weston, has this form been confirmed?" Flora, from her station near the side wall, said, "It's the form currently in use at the counter, Your Honor. There is a version discrepancy between the counter form and the updated procedure, which—" "So there is a discrepancy," Aldine said. "A minor one," Flora said, in a tone that suggested she understood she had just handed him something. "Minor is a matter of opinion when it comes to procedural compliance," Aldine said. He looked back at Naomi. "This proceeding may need to be continued to allow for refiling with the correct—" "Your Honor." Simone's voice was steady, unhurried. She set her pen down deliberately on the legal pad. "The form discrepancy, if one exists, is between the county's counter supply and the county's updated procedure. My aunt was issued that form by a county employee at a county counter. If the county issued a non-compliant form, the burden of that discrepancy cannot rest with the petitioner." Aldine turned to look at Simone with the full weight of his attention. He did this slowly, the way a person turns a spotlight. "Did I address you?" "No, Your Honor. But lay representatives in small claims proceedings are permitted to speak on behalf of petitioners under—" "I know what lay representatives are permitted to do." His voice had not risen. It did not need to. "What I'm asking is whether you have any understanding of courtroom decorum, because you seem to be under the impression that this is a conversation." "I understand it's a proceeding, Your Honor. That's why I'm asking you to note, for the record, that my aunt received this form from the county and completed it in good faith, and that any procedural deficiency originates with the county's own administrative process." Jasper Knoll, at his table, cleared his throat. "Your Honor, if I may, the petitioner's representative is not admitted to the bar, and her statements cannot be treated as legal argument. She's offering a lay characterization of procedural liability, which—" "Your Honor," Simone said, still at the same measured pace, "Georgia Rule of Civil Procedure 2.1, applicable to small claims proceedings, does not require bar admission for lay representatives in cases involving property matters under the small claims threshold. The petitioner is entitled to representation by a non-attorney family member. I would ask that Mr. Knoll's objection be noted, along with this clarification." Another silence. A different quality than the first one. This one was the silence of people recalibrating. Jasper Knoll looked at the surface of his laptop as though something on the screen had become extremely interesting. Flora, near the sidewall, had become very still. Dahlia Oren's eyes moved from her screen to Simone, then back to her screen. This was the second time. The first had been when Simone requested that Aldine's initial comment be noted in the record. This time, Dahlia's gaze stayed on Simone 2 full beats longer before returning to the keyboard. Aldine looked at Jasper, then at Simone, then at his docket sheet. "You seem very prepared for an administrative matter," he said. "My aunt has been rescheduled 4 times, Simone said. "I had time to prepare." Something passed across Aldine's face. Not quite irritation. He was too practiced to show irritation plainly. Something more considered. He was recalibrating too, and Simone could see it, and she wrote nothing about it because she did not need to. She would remember. "We'll address the form question," he said, setting the docket sheet down. He turned to Naomi. "Tell me about the fence." Naomi explained the fence. She was clear and specific. Dimensions, materials, the height at the property line, which had exceeded the code limit by 4 inches, and had been corrected by her contractor, whose work order she had in the tab folder. She had photographs. She had the timestamps. She had everything. Aldine listened with his pen still. He let her finish. Then he said, 4 inches over the line for how long? I'm not sure exactly when it got to that height, Your Honor. The fence is... You own the property. You're not sure how long your fence was out of compliance? The fence was installed by the previous owner in... So you purchased a property with a non-compliant fence, and now you're asking the court to dismiss a citation based on the fact that you corrected something you should have corrected when you bought the property. Naomi opened her mouth and closed it again. She had not prepared for this angle. She looked at Simone. Simone looked at Aldine. Your Honor, the citation was issued in March of this year. The relevant question is whether the violation was corrected and properly documented before the citation deadline, which it was, with more than 2 weeks to spare. The timeline of the fence's installation is not at issue under the code. I'll determine what's at issue, Aldine said. Of course, Your Honor. I'm asking that the record reflect the petitioner's good faith correction within the statutory window. You keep asking for things to be noted in the record. Because the record is the protection available to a petitioner in these proceedings, Your Honor. It's the appropriate mechanism. He stared at her, the kind of stare that, in 22 years, had made lawyers trail off mid-sentence and defendants lose their place in rehearsed statements. It was a stare designed to communicate, I hold the power in this room, and you would do well to feel it. Simone held the stare with an expression of patient, respectful attention. She was looking at a judge. She was in a courtroom. She was behaving exactly as a person who understood both should behave. She was also, in the breast pocket of her jacket, 8 minutes into a clean audio recording. Aldine looked away first. He looked at his docket sheet. He made a mark on it with his pen. We'll address the renewal form with the administrator, he said. Mr. Knoll, is the county prepared to speak to the form version? Question. Jasper did not look up from his laptop. The county's position is that the petitioner bears responsibility for filing the current form, regardless of what was issued at the counter. Your Honor, Simone said immediately, if the county's position is that a citizen bears responsibility for a government error in form distribution, I'd ask that position be stated clearly on the record, along with the county's explanation for why the counter form and the online version differ. Jasper looked up now. He looked at Simone with the expression of someone who has just stepped on something unexpected and is trying to determine what it was. The online portal discrepancy is a technical matter being addressed by the county's IT. Then the discrepancy is acknowledged, Simone said. Not loudly, not triumphantly, factually, the way you confirm something that has just been established beyond dispute. Jasper closed his laptop slightly, not all the way, just enough to signal the conversation had shifted in a direction he had not anticipated. Aldine set down his pen again. You are trying my patience, he said to Simone. I want you to understand that this courtroom operates on the basis of judicial efficiency. And what you are doing right now is not efficient. I'm ensuring my aunt's rights are properly documented in the record, Your Honor. I understand efficiency is important, so is accuracy. What I see in front of me, Aldine said, and now his voice took on a different quality, not louder, but more personal, more interested, is a woman who came into my courtroom dressed for a casual afternoon and who wants to tell me how to run my proceeding. I've been on this bench for 22 years. I've seen every kind of representation walk through that door. And what I can tell you is that attitude and a folder of papers does not constitute legal standing. Simone wrote on her legal pad. She wrote, Comment reappearance, attire, 9:14 a.m. She wrote it slowly, deliberately, in full view of the bench. Aldine watched her write. He watched her cap her pen. Did you just write that down? He asked. Yes, Your Honor. What did you write? I noted the comment and the time, Your Honor, for the record. I am the record in this courtroom, he said. And there it was, not a legal argument, not a procedural position, but the unguarded statement of a man who had spent long enough on a bench that he had begun to confuse the office with the person. Simone had been waiting for something like this, not because she had engineered it, because Chester Aldine, presented with a black woman who would not shrink from him, could not help producing it. She did not respond to it. She set her pen down. She folded her hands on the legal pad. She waited. In the gallery, Naomi was watching her niece with an expression that had shifted quietly from fear into something else, something that had not had a name for it yet, because Naomi had not yet understood what she was witnessing. Brock Callum, near the east wall, had moved 2 steps closer to the podium. Not dramatically, just measurably. Dahlia Oren was typing again, but her screen, angled slightly toward the room, showed a document that was not the standard docket entry form. It was longer. It had more fields. It was the kind of document a clerk opens when she is making a separate record of her own. The morning continued. Aldine turned to Jasper and asked for the county's position on the form question, and Jasper restated his earlier argument about petitioner responsibility, and Simone restated the counter-argument about government-issued forms constituting reasonable reliance. Neither of them raised their voices. It was a procedural dispute conducted in ordinary tones, but it had the quality of 2 people who both understood what was actually at stake, which was not a fence citation. What was at stake was whether Naomi Bryce would be dismissed today or rescheduled again. And behind that question, invisibly, was a larger one that only Simone and Ezra Cole and the Commission's case file knew about. Whether Chester Aldine, in the performance of his judicial duties, had a practice of creating exactly these kinds of obstacles specifically for people who look like Naomi Bryce. Simone produced the printout. She had pulled it the previous evening from the county's official portal. A screenshot with the URL visible, the date visible, the form version number in the bottom corner. She placed it on the podium surface beside Naomi's tab folder and read the version number aloud. Version 6.2, effective January 15, 2024. My aunt's renewal certificate carries version 6.2. The form currently in issue. Flora Weston, near the sidewall, made the small, involuntary movement of someone who has just realized they should have checked something before the hearing started. She looked at her clipboard. She looked at the screen on the counter near the door. She looked briefly and very deliberately at nothing. The form is current, Simone said. There is no discrepancy between the form my aunt was issued and the form required by the current procedure. I'd respectfully ask the court to note that the form challenge has been resolved in the petitioner's favor and to proceed to the substantive question of whether the correction was timely and sufficient. Aldine looked at Flora. Flora had the expression of someone who had just been handed a problem she did not want to own. She nodded, very slightly. The form will be accepted, Aldine said. He said it without inflection, as though he had never doubted it. Simone did not allow herself a reaction. She simply moved to the next section of her legal pad. That was the first round. The technical round, a procedural challenge met with a document, a discrepancy identified and resolved, a position defended without aggression. Simone had not raised her voice once. She had not accused anyone of anything. She had simply presented accurate information in the correct sequence. Jasper Noel spent the following 4 minutes attempting to raise the question of the fence's prior non-compliance as an issue of petitioner culpability. A theory Simone recognized as legally unsubstantiated but practically effective because it took time, and time was a resource these proceedings consumed fastest. Mr. Noel's argument, Simone said when Jasper paused, conflates the history of a property's condition with the petitioner's compliance during the citation period. The code violation citation covers the period from March 7th through the correction deadline. My aunt corrected the violation on March 28th. The certificate was filed April 3rd. Under OCGA, Section 3674, a property owner who corrects a cited violation within the specified window and files appropriate documentation is entitled to dismissal of the citation. The history of the fence prior to the citation period is not relevant to that determination. She had read the citation on the counter in the hallway outside Room 4 that morning, from the Georgia Local Government Code reference materials posted beside the docket board. She had not memorized it. She had taken a photograph of the relevant section with her phone at 8:19 a.m. and had reviewed the language twice. She did not say any of this. She simply read the statute number from her legal pad, where she had written it at 8:21. Jasper looked at her. He looked at Aldine. He looked at his laptop screen. "Your Honor," he said, "I'd like a moment to verify the statute citation." "Take your time," Simone said, and instantly regretted the phrase. Not because it was aggressive, but because it was too close to irony, and she had not come here to be ironic. She was there to document. Aldine, however, caught the tone. He looked at Simone with sharpened attention. "Ms." He paused as though her name was something he did not feel compelled to use. "You will allow the court its process." "Of course, Your Honor." Jasper verified the statute on his laptop. His expression, when he looked up, had the careful neutrality of someone confirming something they had hoped not to confirm. "The statute is accurate as cited," he said. There was a silence. Then Aldine said, "The form is accepted. The statute is noted. We'll take a 5-minute recess." He stood and walked through the door at the back of the bench before the bailiff had completed the formal announcement. Brock Callum called it anyway. "All rise," and the room stood and then settled back, and the sound of quiet conference broke out in the gallery. The young man near the wall leaned to his attorney and whispered. Two women in the back row spoke in low voices. Naomi stepped close to Simone. "What just happened?" "He's regrouping," Simone said quietly. She made a note of the recess time. "The form argument didn't work. He'll try a different approach." "Are we going to win?" Simone looked at her aunt's face. The lines of it, the careful composure over something that had been frightened since March 7th. The absolute dignity of a 71-year-old woman who had pressed her dress and organized her folder in 4 colors and taken the bus to a courthouse 4 times because the alternative was to let someone take something that was hers. "We came here for a dismissal," Simone said. "We're going to get it." What she did not say, because she could not, was, "And that is the least of what is going to come out of this morning." Aldine returned from recess in a different register. The performance of exhausted patience had been exchanged for something more direct. He settled back into his chair and looked at Simone without the preliminary of the docket sheet, which told her something. "You've been very talkative this morning," he said. "I've been representing my aunt's interests, Your Honor." "You've been managing my courtroom," he said. "There's a distinction." He leaned forward, forearms on the bench. "Let me be plain with you. The petitioner's documentation appears to be in order, and I will address that in my ruling. But the manner in which you have conducted yourself, interrupting opposing counsel, citing statutes in a small claims proceeding as though this is federal court, treating my administrative staff as if they have something to answer for, is exactly the kind of behavior that does not serve your aunt. It serves your desire to be heard in a room where you are not the attorney." Simone looked at him. She had written the words, "your desire to be heard," on her legal pad. She set her pen down. "Your Honor," she said, "my aunt has been rescheduled 4 times for a matter that should have been dismissed at first appearance. Each of those reschedules cost her a day of work, a bus fare, and 4 months of anxiety about a 14-year-old rental property she bought with money she saved for 15 years. I am not managing your courtroom. I am trying to get her a fair hearing." "Are you suggesting my courtroom is not fair?" The question sat in the air. Everyone in the room understood its weight. This was the trap. Answer yes and face contempt. Answer no and concede the premise. Simone answered neither. "I'm suggesting that my aunt deserves to have her documentation addressed on its merits, Your Honor. I believe that is what this proceeding is for." Aldine was quiet. He looked at her for a long moment, the kind of look that in 22 years had concluded with a gavel and a dismissal of whatever the person below was saying. He was doing the calculation. She could see it. He picked up his pen. "I'll note for the record," he said, "that the lay representative in this matter has been unusually aggressive and has tested the limits of what this court's patience allows. That is also part of the record." "Noted," Simone said. Something crossed his face at that word, a brief, visible tightening. Ms. Again the pause. Again the refusal to use her name. What is your name? Simone Bryce. Ms. Bryce, what do you do? The room went very still. It was the question she had been expecting since approximately 9:14 a.m., when he had watched her write in her notebook and asked what she had written. She had an answer prepared, accurate, simple, the kind of answer that redirected without lying. I'm here in support of my aunt, she said. That's not what I asked. I understand, Your Honor. I'm here as her representative in this matter. Aldine stared. He had the look of a man who knows he is missing something, but cannot identify what it is. He glanced at the blue folder on the podium, the one she had brought in, the one she had touched once on arrival and not opened since. His gaze rested on it for approximately 2 seconds. He did not ask about the folder. He looked back at his docket sheet. Let's proceed to ruling, he said. What happened next took 11 minutes and covered, in Simone's notes, 4 full pages of her small ruled notebook. Aldine issued a preliminary finding that the petitioner's documentation was substantially in order, a finding he framed in language so qualified and hedged that it barely constituted a finding at all. He then suggested from the bench that a 30-day administrative review of the form version question would be appropriate before a final ruling, and that the matter should be continued accordingly. Jasper Knoll nodded, which was not a surprise. Simone set down her pen. She picked it back up. She looked at Naomi. At the set of Naomi's jaw, the slight darkening under her eyes that came from 4 months of carrying something heavy, and she made the decision that Ezra Cole had told her not to make. She reached into her tote bag. She removed the blue folder. She set it on the podium surface, and she opened it. She did not take anything out of it yet. She simply opened it so that the first page was visible. The header of the first page, in the Commission's standard formatting, read, State Judicial Conduct Commission, Case Number JCC 2024-0047. She did not read it aloud. She did not point to it. She simply had it open on the podium in front of her. Your Honor, she said, before the court continues this matter, I'd like to place on the record, formally, that the Georgia Code of Judicial Conduct, Canon 2, Rule 2.3, prohibits a judge from engaging in conduct that manifests bias or prejudice in the performance of judicial duties. I'm asking that my objection to a further continuance, on grounds that the petitioner's documentation has been verified as complete and compliant, be noted in the official record. There was a silence of approximately 3 seconds. Then Aldine said, Close that folder. Your Honor, close it. I'm exercising a petitioner's right to place an objection on the record. Bailiff. Aldine's voice had changed. The measured control was still there, but something had shifted beneath it, something tighter, faster. Remove the representative from the podium. Brock Callum came off the wall. Simone closed the folder. She placed her legal pad on top of it. She turned to Naomi. Don't sign anything, she said, quietly enough that only Naomi could hear. Don't agree to any continuance without me. I'll be outside. Naomi's hand found her arm for 1 second. Then Simone stepped away from the podium and walked toward the courtroom door with Brock Callum 3 paces behind her. She did not rush. She did not look back at Aldine. She walked at exactly the pace of a person who has chosen to leave, not one who has been ejected. At the door, she paused. She turned, not toward Aldine, but toward Dahlia Oren. Their eyes met across the room. Dahlia was not typing. She was watching. And in the expression on Dahlia's face, beneath the professional composure that 11 years in that room had built into something nearly impenetrable, Simone saw recognition. Not surprise, recognition. As though Dahlia had been waiting a long time for someone to walk through that door and open that folder. Simone nodded once. Then she pushed through the door and walked into the hallway. Behind her, the heavy oak door swung closed. The sound of the latch catching was clean and final, like the period at the end of a sentence. She did not stop in the corridor. She walked past the docket board, past the security checkpoint, through the main lobby, and out the front entrance of the Caldwell County Courthouse into the late morning air. She found a concrete bench on the east side of the steps, out of the direct sunlight, and sat. She took the recorder out of her jacket pocket. She did not play it back. She simply held it in her hand for a moment, the weight of it, the small, warm solidity of the evidence inside it. Then she took out her phone and called Ezra Cole. He answered on the second ring. "Exhibit 14 is live," she said. "I need a case number for a contempt order issued by Judge Chester Aldine in case CV 2024-1183, Caldwell County Circuit Court, as of approximately 9:38 a.m. today." A pause, brief. Ezra processing. "Are you safe?" he asked. "I'm on the courthouse steps. Give me the room and docket number." She gave him both. She heard typing on his end, quick, precise, the sound of a man who had been waiting 14 months for a phone call that sounded exactly like this one. "You opened the folder," Ezra said. It was not a question. The language was Rule 2.3, straight from the wall posting in the room. Nothing proprietary, nothing from the file. Another pause. He issued contempt over a rule citation read from a public notice. "Yes." The typing stopped. "Ms. Bryce," Ezra said, "that contempt order is now Exhibit 14 in case JCC 2024-0047. I'll have the commission paralegal pull the recording request for the official court transcript within the hour. Do not go back in." "My aunt is still in there." "She'll be fine. He got what he wanted. He has the room back. He'll give her the dismissal." A brief pause. "He will give her the dismissal," Ezra said again, with the careful emphasis of someone confirming a prediction, not making a hope. Simone looked at the courthouse door, the old pale brick of the building, the weight of 1941 in every course of it, the accumulated decisions. "He looked at the folder," she said. "What did he see?" "The header, case number. He didn't read it, he just saw it open." Silence. Then, "Does he know your name?" "He asked, I told him." "Does he know your role?" "No." "Good, keep it that way for now." Another pause, and in it Simone could hear the particular quality of Ezra organizing a sequence of next steps. "The pre-disciplinary conference is 6 weeks out. I'll advance the scheduling request today. What you have from this morning, the contempt order, the statements on the record about your appearance, the documented intimidation at the podium, combined with what we already have, this is sufficient." Simone looked at the recorder in her hand. "Not yet," she said. "Not yet? There's more." She set the recorder on the bench beside her and looked at the front entrance of the courthouse, where a man in a gray suit was holding the door for an older woman with a shopping cart full of documents. Ordinary people, ordinary morning, there's always more. Ezra was quiet for a moment. "All right," he said. "Be careful." She ended the call. She sat on the bench in the sun. The morning was heating up toward noon, the kind of Georgia heat that doesn't announce itself and then is everywhere at once. She put the recorder back in her jacket pocket and placed her notebook on her knee and looked at what she had written since 8:22 a.m. 14 pages, single side, small ruled. Every name, every time, every word of consequence. She turned to a fresh page. At the top she wrote, "Post removal, 9:40 a.m., Courthouse East Steps." Then she wrote one more thing. Not a fact, not a note, but a question she had been carrying since she walked into that room. How many times? Not today, not in this case. How many times, in how many cases, with how many people who did not have a folder and a recorder and 14 months of preparation behind them? The door of the courthouse opened again. Naomi came through it, the green dress with the collar, the plastic folder clutched against her chest, her silver hair still pinned perfectly. She stood at the top of the steps and looked out until she found Simone on the bench below. She walked down slowly, one step at a time, holding the rail. When she reached the bottom, she stopped in front of Simone. "Dismissed," she said. "New judge." Came in, looked at the certificate, said, "This is in order," and dismissed it in about 2 minutes. Simone nodded. "I know." Naomi sat down on the bench beside her. They sat in the sun without speaking for a moment, the way people sit when something is over, but the weight of it hasn't quite lifted. "Baby," Naomi said finally, "who are you here as?" Simone looked at her aunt. She looked at the courthouse, at the front door, at the pale brick, at the window of room 4 on the second floor, where the blinds were partially drawn. "I'm here as your family," she said, which was true. She put her hand over Naomi's and squeezed once. The blue folder was still in her tote bag. The recorder was in her jacket pocket. The 14 pages of notes were on her knee. In the second floor window of Courtroom 4, a figure appeared briefly at the edge of the blind. A silhouette, standing, looking down at the steps. Then it moved away. Chester Aldine, in room 4, was still the most powerful person in that building. He still had 22 years of decisions behind him, a robe on the back of his chair, a docket full of cases involving people who could not easily challenge him. And he had just become Case JCC 2024-0047, Exhibit 14, in the file of the woman sitting on the steps below his window. He did not know any of that yet. The folder on Simone's lap did not move. The morning continued around them, ordinary and warm and full of its own ordinary weight. A pigeon crossed the top step. A car horn sounded 2 blocks away. Naomi held Simone's hand without asking why. 14 pages, 1 recorder, 6 weeks. And somewhere, in the second floor window, a silhouette that had already disappeared, leaving only the blinds swaying once, gently, like something that had almost been seen. The 6 weeks that followed the morning at the courthouse were not dramatic. That was the thing about investigation work that people who had not done it failed to understand. The weight of it was not in confrontation. The weight was in the accumulating record, in the methodical work of converting memory into documentation, and documentation into evidence, and evidence into a sequence of facts so clear and so complete that no reasonable person, presented with them in sequence, could explain them any other way. Simone worked from a rented apartment in Atlanta that she had taken on a short-term lease 2 months earlier, when the commission had approved the field phase of case JCC 2024-0047. The apartment was on the 4th floor of a building on Peachtree Road, small and clean, with a desk she had positioned to face the window. The view was of a parking structure, which suited her. Nothing to distract from the work. The audio recording from Courtroom 4 was submitted to the Commission's Digital Forensics Unit the day after the hearing. The unit confirmed authenticity, logged it as Exhibit 14 with a chain of custody certification signed by the unit's technical director, and returned a full transcript within 72 hours. The transcript was 17 pages. Simone read it twice. She marked 3 passages in the margins with a single asterisk each. Not the most inflammatory ones, but the most legally precise. The ones that would still mean what they meant after Aldine's attorney had spent 6 months arguing context. The FOIA response arrived 12 days later. She had submitted the request 3 months earlier, during the preparatory phase, before she had set foot in Caldwell County. A formal request to the state court administrator's office for sentencing and bail data from Chester Aldine's docket, spanning 11 years, disaggregated by defendant demographics where available. Government records requests of this nature take time as a matter of institutional design, not accident. The system moves slowly, partly because it is understaffed, and partly because the people who manage it have learned that speed does not serve institutional interests. What came back was a spreadsheet with 4,062 rows. Each row was a case. Each case had a defendant demographic field, a charge classification, a bail determination, a sentencing outcome, and a comparison column cross-referenced against the county's aggregate averages for that charge category. Simone printed the summary pages. She did not print all 4,000 rows. She printed the summary, which her commission data analyst, a quiet man named Kelvin Frost, who had been at the commission for 9 years and had never once described his work as anything other than organizing numbers, had distilled into 3 figures. Kelvin had written them in his standard format, a single sheet, white paper, no headers, just numbers in the center of the page with a line of explanatory text beneath each. The first figure, defendants identified as black in Aldine's courtroom, received bail amounts averaging 43% higher than defendants of other racial identifications charged with equivalent offenses across the same 11-year period. The second, first-time offenders identified as black were sentenced to custodial terms, meaning actual jail time, at a rate 2.4 times higher than non-black first-time offenders charged with equivalent misdemeanor classifications. The third, civil cases in which the petitioner was identified as black were continued to subsequent hearing dates at a rate 3 times higher than equivalent civil matters with non-black petitioners. Simone looked at those 3 numbers for a long time, not because they surprised her, because they deserved to be looked at, because behind each decimal point and each percentage was a person who had taken a day off work, pressed their clothes, taken the bus to the courthouse, and sat in Chester Aldine's room and received something they called justice, and that was not. She filed Kelvin's sheet as Exhibit 3, which was where the data had always been scheduled in the commission's numbering sequence, but which now had a weight that earlier in the investigation it had been building toward. 3 numbers, 11 years, 4,062 rows. She was still at her desk looking at those numbers when her phone rang. The number was a Caldwell County area code she did not recognize. "Miss Bryce," the voice was careful, measured, a woman's voice, with the particular quality of someone who has decided to do something difficult and is moving through it before she loses her resolve. "This is Dahlia Oren. I'm the court clerk for Room 4. We met, briefly, a few weeks ago." "I remember," Simone said. A pause. "I'd like to speak with you, not by phone. Is there a time you could come to Caldwell County?" "I can be there Thursday," Simone said. "I'll come to you wherever is convenient." "Not the courthouse," Dahlia said quickly. "There's a diner on Route 9 called Harlan's. I know the owner. We can sit in the back." "Thursday at noon," Simone said. "Noon." Another pause. "Miss Bryce, I've been thinking about this for 3 years. I want you to know that before I say anything else. 3 years." Simone set down her pen. "I know," she said. She drove to Caldwell County on Thursday morning, arriving at Harlan's Diner 40 minutes early. She ordered coffee, sat in the back booth, and waited. Dahlia Oren arrived at 11:58 am, small, precise, with the kind of posture that came from years of sitting at a desk in a room where attention mattered. She wore civilian clothes, a pale blouse, dark trousers, a canvas tote bag over her shoulder. She sat across from Simone without a greeting and placed the tote bag on the seat beside her. "I have a notebook," Dahlia said. 3 years of notes. Every time he said something, I wrote it down. I have dates, case numbers, direct quotes, 51 entries." She paused. "I know it's not testimony from the people he hurt. It's just what I saw." "That's not just anything," Simone said. "That's documentation from inside the room. That's evidence." Dahlia looked at her hands. She had the expression of a person who has carried something heavy for so long they have forgotten that it is not a normal weight. "He knows I've been watching. Not because I've said anything, but there's something he does when he knows a room is paying attention. He gets quieter, more careful. And for a long time I thought that meant I was doing something wrong by paying attention. That maybe I was misreading him. That maybe the pattern I was seeing wasn't. The data confirms the pattern, Simone said. She did not elaborate. She did not need to. Dahlia looked up. Something shifted in her expression. Not relief exactly, but the specific quality of a weight being shared after a long time of carrying it alone. She reached into the tote bag and placed a notebook on the table between them. Black cover, college ruled, not unlike Simone's own. "Will this help?" she asked. "Yes," Simone said. "It will." The notebook went to the commission's office that same afternoon, photographed page by Simone's phone in the parking lot of Harlan's Diner, with the authentication timestamp visible in each frame. It became Exhibit 9, Dahlia Oren's contemporaneous record of 51 incidents spanning 37 months. Every entry cross-referenced with an official case number from the public docket. Every direct quote written down the same day it was spoken. Simone drove back to Atlanta. She did not listen to anything in the car. She drove in silence and let the Georgia landscape move past the windows. The red clay of the shoulders, the long flat fields, the pines standing in their patient rows. She thought about Dahlia sitting in room 4 for 3 years with a notebook in the drawer, writing things down because she knew they mattered, even when no one was asking. Some people wait their whole careers for someone to ask. Back in the apartment on Peachtree Road, she compiled the FOIA data, the audio transcript, Dahlia's notebook, the contempt order from case CV 2024-1183, certified by the clerk's office and formatted as Exhibit 14. The sworn statements were still incoming. Ezra's office had reached out to 3 former defendants identified through the data analysis, people whose cases showed the clearest statistical anomalies, and 2 of them had agreed to speak. By the end of the second week, 7 had agreed. Their statements were formatted individually, notarized, and filed as Exhibits 15 through 21. On a Wednesday evening in the 5th week, Simone printed the full evidentiary index. 21 exhibits, 14 months of investigative work, organized in sequence, each piece cross-referenced to the others. She read it from the first page to the last, slowly, the way you read something you have built and are examining before you trust it with real weight. Then she called Ezra. "We're ready," she said. "The pre-disciplinary conference is scheduled for Monday, 9 a.m., he said. "Chief Justice's conference room, 7th floor, State Judicial Building. Aldine will be present with counsel. You'll present as the lead investigator of record." She was quiet for a moment. "He's going to recognize me," she said. "Yes," Ezra said, "and his attorney will move to dismiss on grounds of something. Entrapment, misconduct, the manner in which evidence was gathered." "His attorney will try several things," Ezra said. "None of them will succeed because nothing about how this was conducted was improper. You were a private citizen in a public proceeding. The recording was legal under Georgia's one-party consent statute. The FOIA request was filed through proper channels. The witness statements were gathered voluntarily." A pause. "His attorney will try. That is what attorneys do. But the file speaks for itself." 21 exhibits, she said. 21 exhibits, he confirmed. "Get some sleep." She did not sleep well, but she did sleep. Monday arrived with the particular quality that important days sometimes have. Ordinary weather, ordinary traffic, ordinary coffee in a paper cup from the lobby of the Judicial Building. The elevator to the 7th floor was quiet. Simone carried her laptop bag and the printed evidentiary binder and the blue folder, whose spine she had touched each morning of the investigation, the way some people touch a stone they carry for steadiness. The conference room was a long rectangle, with windows on one side and a view of downtown Atlanta's rooftops. A mahogany table ran its length. At the far end, 3 people were already seated. A representative from the Chief Justice's office, a commission panel member named Iris Chalk, who Simone had briefed 3 times over the previous months, and a third person she did not recognize. A woman in her 60s with reading glasses and the careful composure of someone who had been in difficult rooms for a long time. This woman was introduced as the senior investigative counsel from the state attorney's office, present as an observer. On one side of the table, midway down, Chester Aldine. He wore a dark suit and no tie, and he had the look of a man who has been told many times that he is here voluntarily and has not entirely decided whether he believes it. His attorney, a man named Oswald Burke, compact and precise, with the careful energy of a litigator accustomed to administrative proceedings, sat beside him with a yellow legal pad and a pen. Aldine looked at the door when Simone entered. He looked the way people look when they are not sure what they are looking for. Then he placed her. She saw it happen, the small, involuntary adjustment in his expression. Not dramatic, not obvious, but present. A recalibration. His eyes moved from her face to the binder in her hands and back. Oswald Burke leaned close and said something near Aldine's ear. Aldine's jaw shifted slightly. Simone set her binder on the table, opened her laptop, and sat. "Good morning," she said to the room. Not to him specifically, to the room. Iris Chalk called the conference to order. She read the case number, JCC 2024-0047. She read the respondent's name, the Honorable Chester Aldine, Circuit Court Judge, Caldwell County, Georgia. She noted the purpose of the conference, a pre-disciplinary review under the Georgia Code of Judicial Conduct, preceding a formal hearing by the full Judicial Qualifications Commission, scheduled for 60 days hence. Oswald Burke made the first move within 4 minutes. He requested a brief recess to allow him to confirm the identity and role of the lead investigator, whose involvement in the case had not been disclosed to his client in advance. The request was denied by Iris Chalk, with the calm finality of someone who had anticipated it. The Commission's disclosure obligations had been met in full. Ms. Bryce's role had been listed in the investigative file documentation provided to Respondent's Counsel 10 days prior. Burke had not read the file carefully enough. He would not make that mistake again. The conference proceeded. Simone presented the evidentiary record in sequence, beginning with Exhibits 1 through 5, the 5 original complaints, each dismissed or stalled, and the documented reasons for each dismissal. She did not editorialize. She read the dismissal notations aloud, in the Commission's own language, and let the patterns dismissals, citing insufficient specificity, 2 pending reviews with no assigned investigator, no action taken, no timeline established. She moved to Exhibit 3, Kelvin Frost's data summary, 3 figures representing 11 years and 4,062 cases. She read the figures once. She did not repeat them. She moved to Exhibit 9, Dahlia Oren's notebook, 51 entries, 37 months. She read 6 entries aloud, chosen because they were the clearest, the most direct, and because they spanned the full range of the documented period. She read the dates. She read the case numbers. She read the words Chester Aldine had said from his bench, in his courtroom, on 6 different occasions, to 6 different people, in the exact language that Dahlia had written down the same day. Chester Aldine sat without expression through most of this. His attorney made 3 objections. The first was overruled. The second was noted and set aside pending review. The third, an objection to Dahlia's notebook on grounds of authenticity, was addressed when Simone placed before the panel the 63 authentication photographs, each with a timestamp, each showing a page of the notebook alongside the corresponding public docket entry confirming the case number. Oswald Burke looked at the photographs for a moment, then wrote something on his legal pad and underlined it. She moved to Exhibit 14. She read the contempt order, not the full text, but the operative language, noting the date, the case number, the grounds cited by Judge Aldine. She then read the passage from the Georgia Code of Judicial Conduct that Simone had spoken aloud from the bench immediately before the order was issued. She placed the 2 documents side by side in the binder's exhibit section and left them there. Aldine's attorney spoke. Your Honor, this addressed to Iris Chalk. The contempt order in question was issued in response to disruptive behavior by a lay representative who had been repeatedly warned about her conduct. The order reflects proper use of judicial discretion, not misconduct. The order was issued, Simone said, after I read aloud verbatim from a public notice posted in the courtroom. The public notice cites Rule 2.3 of the Georgia Code of Judicial Conduct. I did not interpret the rule. I did not characterize it. I read 7 words of its operative language into the record. She paused. If reading a posted judicial conduct rule constitutes disruption sufficient to warrant contempt, that is itself a question the Commission may wish to examine. Iris Chalk wrote something on her notepad without looking up. Then she asked the question. She asked it after a pause, after she had set her pen down, and she asked it in the same level tone she had used for everything else in the room. Not dramatically, not performatively, but with the precision of someone who has been saving a particular question for the right moment and knows when that moment has arrived. Judge Aldine, she said, in 22 years on this bench, how many formal complaints have been filed against you with this commission? Aldine looked at his attorney. Burke gave the smallest shake of his head, meaning, you have to answer. None, Aldine said. None, Iris repeated. She did not write it down. She did not need to. And how do you account for that? Silence. Not the silence of consideration, the silence of a man who has just understood something about his own situation that he has been actively not understanding for a very long time. Burke began to speak. Your Honor, I'd object to the characterization implied by... I'm not characterizing anything, Iris said. I'm asking the respondent to explain an absence. 22 years on the bench, 5 complaints documented in the record before you, none of which resulted in a finding, none of which were formally referred for investigation until Miss Bryce's review. And before those 5 in the preceding 19 years, nothing. She looked at Aldine. Could it be, she said, because the people who appeared before you understood that filing a complaint meant returning to your courtroom? Burke said, objection. Iris said, noted, and kept her eyes on Aldine. Aldine said nothing. He looked at the table surface in front of him. He looked at the binder with 21 tabs along its edge. He looked, briefly, at Simone, and this time the look was different from every other look he had directed at her. Not contempt, not the managed irritation of a man annoyed by someone beneath his station. Something closer to the expression of a person who has just realized, clearly and completely, the dimension of what is in front of them. Simone looked back at him without expression. She had given him nothing in Courtroom 4, and she had nothing to give him now. She had the record. She had 21 exhibits. She had 3 years of Dahlia Oren's careful handwriting and 11 years of data, and 7 people who had agreed to put their names on sworn statements about what Chester Aldine's courtroom had done to them. She had a contempt order that his own attorney could not explain away without explaining the thing that generated it. She had more than enough. The pre-disciplinary conference concluded at 12:47 p.m. The formal disciplinary hearing before the full Judicial Qualifications Commission was confirmed for 60 days out. Aldine was placed on paid administrative leave, not suspended, not removed, placed on leave, pending the hearing's outcome. This was procedurally standard. It was also, for a man who had derived his sense of self from that bench for 22 years, not a small thing. He walked out of the conference room without speaking. Burke followed, phone already at his ear. The door closed behind them with the same clean sound as the courtroom door 6 weeks earlier. Simone closed her binder. She looked at Iris Chalk, who was gathering her materials at the head of the table with the composed efficiency of someone who had a great deal of work still ahead of her. The hearing is in 60 days, Simone said. The hearing is in 60 days, Iris confirmed. She looked up briefly. Your documentation was thorough, very thorough. She said it the way people say things they mean to be complete in themselves, without elaboration. "Thank you," Simone said. She took the elevator down alone. In the lobby, she sat on a bench near the entrance. Different city, different courthouse, same quality of morning coming through the glass. She called Ezra. "It's done," she said. "Conference concluded. Hearing in 60 days. Administrative leave? Effective immediately." She heard him exhale. Not dramatically, just the small, controlled release of a man who has been managing something difficult for a long time and has just seen one significant step completed. "Raymond Vale," he said, "the ethics referral is moving through the council's oversight committee. The leak to the Caldwell Courier was documented from a county email account. That's the state ethics board's problem now. Has it affected anything?" "The article ran 2 days after you sealed the file," Ezra said. "His name, your general description, the suggestion that an investigation of Aldine was underway. By the time it ran, the evidentiary record was complete and filed. The leak accomplished nothing except documenting that a sitting council member attempted to interfere with a judicial conduct investigation." "Which is its own problem," Simone said. "His own problem," Ezra agreed, "not ours." She ended the call and sat for another minute. The lobby was filling up with midday movement, clerks on lunch, an attorney on his phone, a family with a stroller navigating the security line. The ordinary architecture of a day in a building where things were decided. The formal disciplinary hearing convened 63 days later in the commission's main hearing room on the 8th floor of the state judicial building. It was not a courtroom. No gallery, no bench, no raised platform. A long table for the commission panel, a table for the respondent, a table for the commission's presenting counsel, and 3 rows of chairs behind a divider for authorized observers. Simone sat in the observer section with Ezra Cole. She had no role to play in the formal hearing beyond the record she had already submitted. The record would speak without her. The hearing lasted 3 days. On the first day, the commission's presenting counsel walked through the evidentiary binder, exhibit by exhibit, in the same sequence Simone had established at the pre-disciplinary conference. Oswald Burke made 14 objections. 9 were overruled. 3 were sustained on technical grounds and resulted in minor modifications to how exhibits were characterized, not to what they contained. 2 were taken under advisement and did not meaningfully affect the proceeding. On the second day, 7 people testified. Simone did not know most of their faces. She knew their names from the sworn statements, knew the case numbers attached to their names, the bail amounts, the sentences, the dates they had stood in room 4, and received something that had cost them more than it should have. They testified in their own words, without drama, with the quiet exhaustion of people who have been asked to relive something difficult and have agreed to do it because it is the last thing they can do to make it matter. One woman, who had lost a civil property matter in Aldine's courtroom 4 years earlier, said simply, "I knew it wasn't right, but I also knew that saying so would only make it worse. So I didn't say anything. And then I spent 4 years wondering if I'd been wrong not to." She was not wrong. On the third day, Aldine's attorney presented his defense. He argued that the statistical data was incomplete and subject to alternate explanations. He argued that the audio recording represented isolated incidents taken out of context. He argued that Dahlia Oren's notebook was the record of a single observer whose perspective was necessarily subjective. He argued all of this calmly and with considerable skill. The commission panel of 5 deliberated for 11 days following the close of testimony. Their ruling came on a Wednesday morning. Simone read it at her desk in the apartment on Peachtree Road, on the commission's official notification portal, in the careful, formal language that such rulings always use, because they understand that language, once set in an official record, does not come back. Chester Aldine was found to have violated Rule 2.3 of the Georgia Code of Judicial Conduct, bias and prejudice in the performance of judicial duties, based on the pattern of conduct documented across the evidentiary record. The finding covered 9 specific incidents drawn from Dahlia's notebook the audio transcript, and the testimony of 4 of the 7 witnesses whose accounts were deemed most directly supported by corroborating documentation. The finding did not cover all 21 exhibits. It covered 9 incidents, 4 witnesses, and 1 audio transcript. The statistical data was noted as contextual evidence, not as an independent finding, because the panel determined that the data alone, without case-by-case documentation, was insufficient for a conduct finding under the Commission's evidentiary standards. Kelvin Frost's 3 numbers remained in the record. They did not produce a separate finding. This was not everything. It was not supposed to be everything. The sanction. Chester Aldine was formally removed from the bench. His judicial appointment was vacated effective the date of the ruling. The matter was referred to the State Bar for review of potential disciplinary action under the rules of professional conduct. A separate track, separate timeline, with its own pace and its own outcome that was not yet known. The referral to the bar meant the process was not over. It meant it was entering a different phase. Brock Callum, the bailiff, received a written reprimand from the county sheriff's office for conduct inconsistent with procedure during the handling of the contempt order on the morning of Simone's visit. He was not reassigned. He was not suspended. He was given a letter, placed in a file, and he continued to work. Flora Weston was transferred from Room 4 to an administrative role in the county clerk's annex. The transfer was described in the internal communication as a routine staffing adjustment. There was no formal finding against her. There was, however, a new procedural requirement issued by the county administrator's office, effective the following month. All court forms must be synchronized between counter supply and online portal versions on a quarterly review schedule, with written verification required. The requirement cited no specific incident. It was simply, the administrator's office said, a matter of good practice. Raymond Vale, the city council member who had used a county email account to leak Simone's name and the investigation's existence to a local journalist, received a formal notice of inquiry from the State Ethics Board 44 days after the disciplinary hearing concluded. The inquiry was pending. No finding had been issued. The Ethics Board's standard review timeline was between 8 and 14 months. His attorney issued a statement describing the inquiry as politically motivated and without merit. The statement was logged. The inquiry continued on its own schedule. Naomi Bryce's citation had been dismissed on the day it should have been dismissed, by a substitute judge who read the correction certificate in under 90 seconds and said what was accurate: "This is in order." The case was closed. The property at 442 Harlan Street remained Naomi's. The fence had been the correct height since March 28th. None of this was a fairy tale. None of it arrived whole and completed and wrapped. A man who had spent 22 years in a room where no one could effectively challenge him had been removed from that room. Some of the people he had harmed had been heard in a formal proceeding. Some had not. The statistical record, 4,062 rows, 3 numbers, 11 years, was in the Commission's file, part of the official record of the case, cited as context, not as a finding. It would be there when the next person needed it. That was what partial justice looked like. Not a door closing, a door being, for the first time, accurately labeled. 3 weeks after the ruling, Simone was in her apartment on a Tuesday evening when she opened her email and found one from an address she recognized: Dahlia Oren. The email had been sent at 6:42 p.m. and had a subject line of 2 words: "Thank you." There was no body text, just the subject. Simone read it once. She left it open on her screen and looked at it for a moment, the way you look at something small that has traveled a long distance to reach you. She did not write back that night. She was not sure yet what to say, not because she lacked the words, because some things deserved to be answered carefully, and she had learned a long time ago that the right response to something true was worth the time it took to get exactly right. She closed her laptop. She went to the window and looked at the parking structure across the street. its gray levels lit by fluorescence, a handful of cars at this hour moving slowly through the tiers. Ordinary evening, ordinary city. The kind of night that doesn't announce itself. In Caldwell County, Courtroom 4 had a new judge. His name was on the docket board. He had been appointed on an interim basis, pending a permanent selection process that would take, the state court administrator's office had said, 4 to 6 months. The room was the same, the pale walls, the laminated notices, the clerk's desk in the corner, the east wall where the bailiff stood, the bench with its elevated vantage and its accumulated weight of decisions. Same room, different name on the docket. Somewhere in the commission's filing system, case JCC 2024-0047 was closed and archived. 21 exhibits, 14 months, a contempt order that had become its own undoing, and somewhere in that same system, in a queue that moved on its own slow schedule, 3 new complaints had been logged in the 40 days since Aldine's removal. 3 people, none of whom had known each other, none of whom had been in Caldwell County, each describing a pattern in a different courtroom, in a different county, that had the same particular shape as a pattern Simone Bryce now knew how to recognize. The commission had assigned a preliminary review. The review had been assigned to the Office of the Supervising Investigative Counsel. Ezra Cole, 2 weeks into the preliminary review, had sent Simone a 3-sentence email. He did not use her first name. He used the form of address he always used. Miss Bryce, the preliminary file on JCC 2025-0012 is open. The jurisdiction is Merritt County. When you're ready. She had read it the same evening it arrived. She had not responded yet. She had gone to bed at a reasonable hour and slept without difficulty, which was not something she had managed consistently in the previous 14 months. In the morning, she would answer Ezra. She already knew what she would say. But there was something else first, something that had been sitting in her desk drawer since she returned from Caldwell County, placed there the morning she cleared out the temporary apartment and drove back to Atlanta. A small notebook, college-ruled, black cover, open to the last page she had used. 14 pages of notes from a morning in a courthouse. The question she had written at the top of the final page when she was sitting on the courthouse steps with the recorder warm in her jacket pocket. How many times? She took the notebook out of the drawer. She looked at the question. Then she turned to a fresh page, uncapped her pen, and wrote the date at the top. Then she set the pen down and looked out the window for one moment, at the ordinary Tuesday morning, at the parking structure, at the sky above it that was beginning to go from dark to gray, in the particular way of a day deciding to begin. Then she picked the pen back up. She had work to do. The email marked redacted in case JCC 2024-0047, filed under the header External Communications, Respondent, had never been fully explained. The commission's panel had reviewed it. It had been logged. It showed a date, a sender field that had been partially obscured in the public version of the record, and a subject line that read, "We need to talk before Monday." Monday was the date of the pre-disciplinary conference. The recipient of that email was not Chester Aldine. It was not Oswald Burke. It was not anyone whose name appeared anywhere in the evidentiary binder. The recipient field, in the version of the record available for review, showed 3 letters in a bracket. RAV, redacted. Raymond Vale's middle name was Avery. The investigation into that particular thread was not Simone's. It had been referred. It was on someone else's calendar now, in someone else's preliminary file, in a system that moved at its own pace and in its own sequence. Then she picked the pen back up. She had work to do. The email marked redacted in case JCC 2024-0047, filed under the header External Communications, Respondent, had never been fully explained. The commission's panel had reviewed it. It had been logged. It showed a date, a sender field that had been partially obscured in the public version of the record, and a subject line that read, "We need to talk before Monday." Monday was the date of the pre-disciplinary conference. The recipient of that email was not Chester Aldine. It was not Oswald Burke. It was not anyone whose name appeared anywhere in the evidentiary binder. The recipient field, in the version of the record available for review, showed 3 letters and a bracket. RAV, redacted. Raymond Vale's middle name was Avery. The investigation into that particular thread was not Simone's. It had been referred. It was on someone else's calendar now, in someone else's preliminary file, in a system that moved at its own pace and in its own sequence. But it was there. It had not disappeared. Things written down in the correct format, in the correct proceeding, with the correct case number attached, they do not disappear. They wait. But it was there. It had not disappeared. Things written down in the correct format, in the correct proceeding, with the correct case number attached, they do not disappear. They wait. Chester Aldine spent 22 years on that bench believing that silence was the same as acceptance, that people who did not fight back had decided, freely, not to fight. He was wrong. They were not silent because they agreed. They were silent because the system had been designed to make the cost of speaking louder than most people could afford to pay. Simone Bryce paid that cost differently, not with noise, not with confrontation, but with 14 pages of notes, a clean audio recording, and the patient understanding that documentation outlasts power. She did not win by being louder than Chester Aldine. She won by being more precise. That is the lesson this story carries. Not that the system always corrects itself. It does not. Not that justice arrives on schedule. It rarely does. But that a record, built carefully and held with conviction, is more durable than the person who tries to erase it. Every time someone writes the date, the time, the exact words spoken in a room where they were meant to feel small, they are building something that cannot easily be taken back. If this story stayed with you, subscribe and share it with someone who needs to hear it. And if you have ever sat in a room like Courtroom 4, you already know that silence is not the only option.